Good afternoon and a very happy holiday season and a warm welcome to all the participants. My name is Sanjeev Verma. I'm the chairman and co-founder of Prevail, an encrypted email and file sharing system for protecting CUI for DFARS and CMMC compliance. We wrap up 2022 with the prospect that CMMC is just a few months away from becoming an interim final rule. The CMMC program, as most of you know, has received a tremendous amount of attention from the defense industrial base. Countless articles have been written, hundreds of webinars delivered, and yet something quite remarkable has occurred. What the DoD said, many heard the exact opposite. The DoD said that it's putting a CMMC program into place to audit and ensure compliance with existing, in our underscore existing 800-171 contract requirements to protect controlled and classified information. But many in the DIB, perhaps understandably, heard the opposite. A new program is coming. Let's wait till CMMC is in place, and then we will comply with our current contractual requirements. The purpose of this webinar is to provide contractors, especially small to medium businesses, with a clear, factual understanding of their obligation to implement 800-171 to meet their existing DFARS contract obligations. A second objective is to understand the business and legal risks to current and future contracts assumed by delaying implementation of 800-171. Third, to understand the relationship of CMMC to existing 800-171 clauses under DFARS. And finally, and most importantly, to provide pragmatic guidance from one of the nation's top government contracts, compliance, and cybersecurity lawyers on steps that contractors, particularly SMBs, should be taking to protect their own business interests. We are joined today by Robert Metzger. Bob is a partner at Rogers Joseph O'Donnell, where he's co-chair of the firm's cybersecurity and privacy practice group. He specializes in government contracts, security and compliance matters, and is widely recognized as one of the nation's top lawyers. The fact that he was picked by Microsoft to be their attorney of record for the complex $10 billion Department of Defense Jedi Cloud Services contract speaks to his impeccable credentials. We will ask Bob to demystify DFARS and CMMC compliance and explain in simple terms the most important cyber and compliance areas that owners, senior executives, and IT personnel in SMB contractors should take notice of. Welcome, Bob.
Thank you.
Well, let's start off by giving a brief introduction to yourself. Tell us about your background and particularly that in cyber and compliance and government contracts.
I am a litigator by training, and I've specialized in government contracts for my whole career. And over the course of that career, I've represented many companies in aerospace and defense, healthcare, and information technology. My work has included almost every form of compliance issue or dispute that can arise. Advice to companies on how to comply with clauses they don't understand or question. I've also responded to compliance disagreements or difficulties for companies large and small. I've been responsible for both internal investigations and the response to federal investigations. I've represented many companies, both public and non-public, in the Defense of False Claims Act proceedings, whether brought by the Department of Justice or by a whistleblower. Obviously, I've litigated bid protest cases with values up to $10 billion. For those who might know, earlier in my career, I was an equity partner at Kirkland & Ellis doing litigation for government contractors. And Technically, I'm a retired former partner of Gibson, Dunn & Crutcher, where I was co-chair of government contracts department. Today, my practice has a heavy emphasis upon security, both cyber and supply chain. And today, I advise many companies from very small to extraordinarily large on cyber strategy, compliance, disagreements, disputes, investigations, and I do have one active matter where I'm assisting on a Cyber False Claims Act matter.
Well, those are impeccable credentials, Bob. So let's get down to our audience, and I'm intentionally going to ask you questions from the perspective of an SMB owner or an IT executive in a small to medium business that is somewhat confused about regulations. So let's start with our very first question. If a contractor handles controlled and classified information and has a DFARS 7012 clause in their contract, what are they required to do to meet their contract obligations?
Oh, you have to perform in accordance with the requirements of the 7012 clause. In various forms, that clause has been around a long time. And so it's very likely that most, if not every company or person listening has a contract with that clause, either from the government or flowed down from a prime. The current version of the clause went into force in 2019. And it essentially says that companies have to deliver adequate security to protect covered defense information. Covered defense information includes, or is largely the same as controlled unclassified information. In order to do so, companies are required to implement the security measures, sometimes called requirements, that are in NIST Special Publication 800-171. There are 110 such requirements, I think, in 14 families of security controls. Each of the 110 requirements is expressed originally in just a single sentence. Another important part of the current requirement, perhaps equally important, is the obligation of defense contractors to give notice to the Department of Defense when there is an incident or breach that might cause the compromise of the confidentiality of controlled unclassified information.
Thank you for the brief introduction over there, Bob. So let's move to a contractor that has a DFAR 7012 clause in the contract, but determines for a variety of reasons that it's okay to wait to implement 800-171, either because they perceive limited risk, or they feel CMMC is coming, or that nobody's checking. And so that's a prudent, in their judgment, conclusion. Is that a reasonable conclusion to draw?
No, it's a risky conclusion. Every government contract has a significant number of clauses that are incorporated by law or by regulation. And the 7012 clause is one of those. If you're a government contractor, you're familiar with the list of clauses that are incorporated by reference, as well as those that are included in full text. Typically, 7012 is in full text, but not in all cases. I would ask you, the audience, how many times you have looked at any of the required clauses and made a determination that you don't have to do it. Essentially, the argument that you can ignore 7012 suggests that you would be willing to knowingly decide not to comply with something that is a contract requirement. 7012 is known to companies when they bid. It's evident when they take a contract. It is in force today. CMMC is really beside the point of the present obligation to comply and the present risk that would accompany failure to comply. And those risks are not just compliance, and they're not just the exposure to breach of contract. If you have controlled unclassified information, you are in possession of information which the government has concluded that law or regulation require you to protect. And if you fail to protect them, the government will be injured. And there could be consequences in the contract and outside the contract if it were found that you willfully or even negligently neglected those responsibilities.
Bob, you mentioned that there are two requirements in DFARS that you highlighted. The first is the requirement to protect CUI using the 110 controls of 800-171. And the second was incident reporting requirements. Can you provide for us a little bit more color on these 800-171, 110 controls? So if you're a contractor that has CUI, what does this clause in sort of practical terms ask you to do?
Well, it's really important to look at SP 800-171 yourself. And perhaps equally important to look at the official basis for assessment, which is the companion document 171A. Now, some people and smaller companies who are less informed will look at these things and say, this is just too much information. I can't cope. But if you actually kind of focus upon the 110 individual requirements, and you start by looking just at the single sentence description, well, you'll see pretty rapidly that the families of controls and the requirements as described actually are practices and policies that most companies of ordinary prudence do or should employ in the course of their business. When NIST wrote this 171 standard, it was not trying to create some custom tailored, super exacting, impossibly difficult to understand standards specialized for government contractors. Not at all. There are such documents, something called 853, but that's not here. 171 was written for commercial organizations, and a fundamental assumption of 171 is that most businesses already are doing these things if they are prudently managed. Now, as you go through the 110 items, there are going to be some that are easy to understand just by the plain words, and some that are harder. There's additional narrative discussion included in 171. You may wonder how it is that you would assess these requirements yourself. Well, you can look to 172. But I want to stress something that's really important. For, I believe, every single one of the requirements in SP 800-171, there is no single answer to what is compliant. You are not required to, deliver the Cadillac or the Porsche answer. In fact, for most, if not every requirement, there is a range of answers that are sufficient. And those answers are informed by the risk of your business and I think tailored to your business circumstance. You can choose answers that are sufficient and that are more in the, the nature of a Hyundai, rather than a Cadillac. No offense to either mark. And so you want to approach these things thinking about sufficiency, but you also want to be complete and aim to be in complete compliance. Ultimately, it does not serve your interest to take government contracts, receive CUI, process or transmit it, and then fail to protect it. You expose that information to theft by ransomware actors, to theft potentially by nation state actors. You expose yourself to a breach of contract. You could be excluded from future government work if you were to be found not to have adequately protected that information. And perhaps equally, arguably even more important, if you're not following practices much like 171, then you've essentially accepted that your enterprise is porous and vulnerable. And the world out there is filled with threat actors, especially ransomware criminals, who would like nothing better than finding a poorly protected small target that they can exploit cheaply and get a ransom from, or where they can take your information and sell it. It happens many times every day, and it can happen to you. And I expect some of you have already experienced this.
Bob, let's dig in a little bit deeper. A common refrain from a great many attendees to this webinar who especially work in IT or compliance say something like this. They say that, look, management has asked them to push out implementation of 800.171 till CMMC comes into force, or say, hey, Bob and others have said there's a range of options, so why don't you just go and, put something bare minimum with a lot of program of actions and milestones and poems. What are the specific things that such an IT person should be sharing with their management in terms of the risks that are entailed by pursuing such a strategy?
Well, I do want to say that my prior comments were not meant to imply or suggest that you should do as little as possible. It was to communicate to the smaller businesses that they can, get started by taking measures that can be accomplished relatively easily. Ultimately, please recall, the 7012 clause requires adequate security. And adequate security includes the implementation of 171. But for many of you, doing the minimum will not produce adequate security. And it is in your business interest to have better than adequate, to have sufficient security in the contemporary threat environment. Why is that? Well, as your security gets better, you become less attractive to hackers, activists, and ransomware criminals. As your security gets better, you are less at risk of having your valuable IP, your proprietary data, and that of your customers stolen and misused. You are less at risk of having to report an incident, and you are less at risk of finding that you can't recover should there be an incident. So I never counsel the minimum. I do advise that you can take a pragmatic view and find solutions tailored to each requirement that work for your business, but you still should want to be, and you have to be, legally compliant. Now, if you're the IT person in a small or mid-sized organization, very likely you have already been frustrated that when you ask for funds from the executives, you're not getting what you want. You're not getting the support that you want. Well, here's the problem. That is not an effective excuse for non-compliance. We've seen in recent development instances where CISOs, even of a very big business like Uber, have been criminally prosecuted for knowing failure to perform cyber obligations and for misleading the government. We're seeing obviously a huge amount of increased attention from regulatory agencies such as the SEC and the FTC. Now they apply, of course, primarily to bigger firms and to public companies. But I'm going to wear my lawyer tie for a moment or hat. And I can tell you for sure that at any size business, if you suffer a cyber attack and great damage is done to the value of your business, there are going to be a lot of people out there who are not just disappointed, but have lost money or had their IP stolen or compromised. And they are going to be looking for ways to recover their damages from you. And so even a small company could find itself exposed to a shareholder suit. Even a mid-sized company or a small could find that a business partner sues it if that small company is not adequately protected its customers' IP. There is a very long list of potential litigants who will come after anyone and anything if they suffer substantial financial damage. Now, you can't protect against every possible attack. Nobody can do that. But you never want to be in a situation where you haven't done what is required by a government contract, because then if something really goes wrong, you're at risk of being sued. And a litigant could say, gee, you were required to meet these 110 requirements of 171, and there's no evidence that you did so. And they would characterize that essentially as proof that you failed to fulfill the obligation to reasonably protect your information and information system. Now, what does the technical person do? I think you have to push back. And I've said this even in big companies. I've said to CISOs at very large companies that there are certain circumstances that they just can't tolerate because they are exposed and the company is exposed. So I think you have to go up the chain of command, and you have to not just ask, but you have to insist for a sufficient commitment of leadership for the personal resources, technical resources, and financial resources to comply. If you don't do that, you are essentially walking off the plank and then, sawing it behind you. Not a good plan. You have poor defenses if a bad event happens, and they happen all the time. And that's irrespective of what consequence there might be to your future opportunities to do other government business or to be a subcontractor to a defense prime.
Bob, following up a little bit on, the mindset. So we'll say, well, look, DFARS 7012 has been in action since 2017 and beyond. And look, the DoD isn't really doing much to enforce it. Therefore, it's probably okay to do so. But in the recent, past, specifically from 2019, the DoD has been acquiring new prosecutorial and implementation, capabilities. What are some of the tools that the DoD has now gained to enforce compliance with 7012?
Well, first, I want to make an obvious point. Every company that takes a government contract and seeks to perform it in good faith knows that there is that long list of special government contract requirements. It's not the same as commercial business. And if you were to take, 50 requirements that are included in, flow down, is it true that every single one of those 50 requirements is subject to regular government enforcement or periodic audit or scheduled assessment? No. I mean, the fact that not everything is enforced or subject to regular assessment or audit hardly means that you are excused from the legal obligation to perform the requirements of the contract, which you accepted as those requirements are stated in the contract. Don't think that the absence of enforcement, even if true, means that you get a free pass. You do not. As your lawyer, if you called me in that circumstance and you said, well, they never really cared about this, why, how can they enforce it now? I'll tell you that has proven to be a very difficult defense. I would want a defense that showed, yeah, something bad happened, but look at all the good things that I did that I can document. Look at my management plan to comply. Look at the progress I've made. Look at how my SPRS score has improved. This idea that we can just throw up our hands and say nobody does it, nobody did it, is just wrong on the merits, and it's a terrible defense if you get into trouble. Now, I want to mention that DoD has a fairly long list of remedies even before you get to False Claims Act. DoD put out a memorandum in June of last year, and I'm going to read it. I mean, it speaks for itself. Failure to have or make progress on a plan to implement NIST SP 800-171 requirements may be considered a material breach of contract requirements. Well, as a lawyer, litigator, contracts lawyer, I will tell you that you could be exposed to damages for a breach. And those damages could be to DoD, although sometimes it's hard to establish them. They could even include as damages a cost of investigation in order to figure out what you did wrong and what you didn't do and how this happened. Also, it says remedies for such a breach may include withholding progress payments, may not matter to you if you're small, and foregoing remaining contract options, and potentially terminating a contract in whole or in part. We've also, even heard talk of contracting officers seeking to reduce the price of a contract because the argument is that they're getting less value from you than they paid for. Now let's talk about kind of the uglier scenario. And unfortunately, I think there is exposure out there at a lot of companies. When you submit that 7019 self-assessment and you put your score into the SPRS system, you're making a representation on behalf of your enterprise. And already DCMA has been doing these medium assessments where they're calling an increasing number of smaller companies and they're saying, hey, we have your score. How can you show that's valid? Do you have a system security plan? Can you discuss or describe the reasons that you came up with this score? And they're finding a dismaying number of companies who essentially seem to have put scores in that have no evidentiary basis. Well, when that happens, you are already skating on the thin ice of a false claim or deliberate representation. And if you found yourself in that on that icy territory, perhaps you would hear from the investigative arm of a military department. You might receive an inquiry from an inspector general. It's even possible that someone in your company will become a whistleblower and bring this to the attention of the IG or the Justice Department or the Customs. And you could find yourself with a whistleblower lawsuit under the False Claims Act, which the Justice Department would then investigate. I have seen all of these things. And I will tell you that the legal fees that you would spend or the consulting fees that you would be required to incur will dwarf in a matter of days what it would likely cost you to have actually secured yourself in accordance with the contract requirements.
Bob, this notion of a material breach of clause is an important one to summarize the obligations to protect 800 CUI under 800-171. Let's move to the second part of DFARS 7012, which are specifically the DFARS 7012 C through G clauses that, as we understand, require prompt reporting of a cyber breach and specific access to IT data in the event of a breach. So my question is, if a company is the victim of just a commercial breach, but they realizes they don't meet DFARS C through G or haven't implemented 800-171, what happens? What's their requirement, first and foremost, to report the breach, and again, the consequences of not being in compliance with either C through G or 800-171?
Well, clause is pretty clear. See, it says that if you, as a contractor, discover a cyber incident that affects a covered contractor information system or a covered defense information residing thereon, well, the contractor is to conduct a review of the compromised covered defense information and is to rapidly report the incident to DoD. You could find many situations where there would be evidence of a breach or compromise, and a ransomware attack is certainly one. Where the intent may not have been to steal covered defense information, but if your system is compromised, if a ransomware attacker gets in there, if any other form of hacker is able to extract information or even seize, control, deny, or frustrate your use of that system, well, you can see, readily that the covered defense information on that system becomes vulnerable or already may have been exfiltrated or stolen or otherwise compromised. So in that situation, what you call the commercial breach, Sanjeev, really is something that requires a report to DoD. And I believe that DoD has been disappointed and is now aware that many fewer companies are reporting breaches than the clause requires. I don't think that is something that DoD will allow to continue. And I know to a certainty that in the Department of Justice Civil Cyber Fraud Initiative, which was announced about a year ago, one of the key things that is sought by this cyber fraud initiative is to enforce the obligation of companies to report cyber events when they are under a contractual duty to do so. Obviously, the government feels that it's harmed if their information or information they require that you protect, that information is compromised and you refuse to, decline, or fail to report it. Well, not only are you at breach of contract, but you could be doing a lot of damage to the government. And understand this. The reason that the government wants you to report an incident is first to understand the damage that the government suffered by the loss or compromise of this information. And the second reason is to try to see if they can learn from the techniques or methods that were used by the attacker, perhaps so that they can warn others. The fact that you make an incident report is not an admission of guilt, not at all. In fact, it's arguably a civic duty and here a contractual obligation as well. But it has always been within the authority of the government, and this is described in some of the instructions that accompany the 7012 clause. They have the authority to come in and to look at your information system, and they require you to keep evidence of the forensics of the breach. And if they conduct that after breach review and find that you've done nothing to protect the information, well, the risk of that contractual consequence increases, and the risk of a referral to an inspector general of an investigative service or even DOJ, it increases as well. It's a bad bet, not only because of the compliance failure, because of the liability risk, because of the harm that your business could suffer for the loss of information, but because of the enormous process costs that you incur if you suffer a cyber event and you don't report it and it later becomes known to the government and generates an investigation or litigation.
Bob, let's move to what you were referring to earlier as DFARS 1719, the requirement now in effect that every contractor that handles CUI should compute and report their 800-171 compliance score to the SPRS, or as you refer to, SPRS database. Can you summarize the gist of this requirement and what executives and IT personnel in a company need to know about this clause?
Well, 7019 is really important. And although it's newer than 7012, it is a present obligation that is imposed on every company that has 7012 and CUI, every single company. Moreover, we expect that within a matter of a few weeks, it's going to be made a permanent clause along with its companion 7020. 7019 says to every 7012 contractor, you have to perform a self-assessment. And you do that using something called the DoD assessment methodology, the most recent version of which came out on June 24th, 2020. And it takes those 110 requirements that I described, and it essentially assigns a value, a number value to each of them. For things that are less important, the number value might be 1. For things that are of middling importance, it could be 3. And for the things that are most important, the value is 5. A middling importance one would be develop and implement plans of action designed to correct deficiencies. A high importance or 5-point item is monitor, control, and protect communications at the external boundaries and key internal boundaries of organizational systems. So you are required to do an assessment using this methodology, compute your score, and then you submit it to the SPRS system, Supplier Performance Review System. You're also required to you're also required to tell them when you expect to close any gaps in performance that were indicated during your self-assessment. As I mentioned earlier, just in the last 6 months, DCMA has started to conduct medium assessments under 7020. And in those assessments, they're calling more or less companies at random of any size. And they're saying, gee, we see you at a score of 76 on the SPRS. How'd you get there? We'd like to see your system security plan. We'd like to see evidence that you implement that system security plan. Well, in a significant number of instances, there is no system security plan, and there is no evidence that the score is supported. And if I were counseling a client who told me that they had gotten that medium assessment call, and if they told me that they really didn't have any evidence to support the score that was claimed, or worse, if they didn't have a system security plan, meaning they hadn't actually done a real self-assessment, I would be telling them to get busy immediately to create a system security plan and to act urgently to show compliance, because they are already 1 foot in a lot of trouble. And the only way they're going to get out of that trouble is to take the remedial action on a rapid basis.
So Bob, again, following up on reporting this score to the SPRS database and intentionally being provocative in my question, it's occurring that, hey, I'm an SMB defense contractor or executive, and I ask my IT folks, listen, do a quick and dirty 800-171 calculation, put a lot of poems in there and report it to the SPRS database. What are the implications I should be aware of if I do these quick and dirty calculations?
The most important implication is the obvious one, namely that you are not compliant and you are not secure. You are required to deliver adequate security, and you are to achieve that adequate security employing SP 800-171. If you take an approach to 171 that essentially mimics the words but does nothing, well, then you are not delivering adequate security. And it's very clear from DCMA guidance as to the DFCAT high and medium assessments that they do not accept and will not give you credit for merely repeating the words of, the requirement. In other words, if the requirement is maintain audit logs and a physical access, and you say, yes, we maintain audit logs of physical access, but you don't actually do it and you can't show it, well, then, you are not going to get the credit for that in the score. But it's really a bigger issue than that. If it's just the veneer of security, then it's not any actual protection of DoD information, of your customer information, of your information. And essentially, everybody in your business is put at risk. If you are too easy a target, you're going to get hacked. If you have no defenses, you're a better business proposition for the ransomware actor. It's for them a business. They want to have the least cost to get the sufficient return on their investment. They'll do a little scoping on you by basically figuring out, say, from Zoom Info, what your revenues are. That's really all they need to know. And then they're going to do an external monitor of your ports and kind of get a sense of whether they can see any of the defenses or practices that would be evident if you were well secure. But if you're not, it's a cheap shot for them to make a ransomware attack. And maybe they'll only get a few $1 million from you, or even $1 million. But I know and have advised companies who are small and have had such attacks, have had to pay that $1 million. I can promise you it is a devastating experience with exposure far beyond the ransomware payment. So look, self-protection is the best reason not to just have a veneer. Self-protection means that you take this stuff seriously and you look to protect yourself, your employees, your lenders, your investors, your customers against the risk that you're going to be penetrated because you weren't secure. And if you are secure, then you are also in compliance. Moreover, if you are secure and you are in compliance with 171, you're also much more likely to qualify for cyber insurance. Whereas if you are insecure, have done nothing, and can't demonstrate the key elements of security, you're not going to get cyber insurance, most likely, or it's going to be extremely expensive with very low coverage. This is a triple lose proposition. Don't.
Bob, can you share again some color on the system security plan, the kind of things that you feel give a flavor to executives or IT personnel that are listening to this webinar on what would you think is a prudent, healthy SSP? And also I'd like to ask you a bit about executive sign-off for the system security plan and reporting the score to the SPRS database. Your thoughts on that?
Well, there's no one-size-fits-all answer for a system security plan. I was talking to a multi-billion-dollar company earlier today that's getting ready for a DFCAT high assessment, and they're going to be sending me some of their documentation, some of the evidence that they have of their security. I expect it's going to be fairly elaborate and intense. However, the business circumstances differ. What you do want, though, is not just to parrot the requirements. If there are policies that are expected or processes that are called upon, you need to be able to demonstrate the system security plan should be supported by evidence that shows that you have these things, train your people to use them, do use them, and keep records of their use. In the end, it's really all about evidence. It's not just what we say we're doing, but what we can show we're doing. And I have said to my litigation clients for decades, I know I don't look, okay, I do look that old. I've said to my litigation clients for decades, don't try to tell me what you thought at the time. Don't try to convince me of what you intended. Don't try to assert to me that you did all the right stuff. If you don't have evidence of it, contemporary, at the time you did it, or before the event that causes the crisis, your intent, the evidence is what matters. And so a system security plan has to be more than a husk, and it should never, ever be misleading. DCMA on their medium assessments is calling people first to ask if you have one, and if you don't, you're in some trouble. but they're also asking you to show that, in fact, you follow it. And you can be in trouble when it becomes clear, as it always does, that you don't really follow it, and you may not even know what it means. This is just asking for trouble. And, maybe the chances, maybe the probability is low that you're going to find yourself on the wrong end of an enforcement proceeding. And maybe you'll get lucky and nobody's going to breach you or, submit a ransomware demand. But you're playing, the odds aren't good. And the stake is very high, because if things go wrong on any of those compliance or liability or risk fronts, you got a disaster on your hand. And that gets to executives. For too long a time, the attitude of many executives was that cybersecurity is a nuisance. I don't understand it, and I don't want to worry about it. And the boards knew even less. That's over, right? That is done and cooked. And if you follow what's being done for public companies now, the SEC has proposed that there be people on the board who have expertise in cybersecurity. Now, CISOs know that they're exposed personally, and C-level executives, even at small companies, can suffer personal exposure to suit. I don't want to be a CEO of a company that feigns compliance, suffers a ransomware or other breach, loses a few $1 million in cost to recover, and is out of business for 6 weeks. I don't want to be that CEO trying to answer the complaint from a shareholder, lender, client, customer. I don't want to answer that and simply say, well, I intended to get to it eventually. I mean, really? I mean, who are you kidding?
Well, so this SPRS score is an important mechanism to link compliance to the obligation to meet 800-171, because you got to go and document how you're meeting it and put that into your system security plan that is evidence of compliance. Let's move on to
let me interject for a second, because you would ask, what's the responsibility of the executive? You are responsible. I mean, if it's submitted on behalf of an enterprise, and if the enterprise submits a misleading SPRS score, they're not going to say, oh, well, this was clearly the fault of the lower level employee who actually made the submission. It's going to be the leadership in the company that are at fault. And I want to mention one other thing about SPRS. The government has made it very clear that the SPRS system contains information about the contractor's suitability to do business with the government. And it is expressly said in different government directives that contracting officers, before they choose who they will do business with, are to look at the information in SPRS. And SPRS now includes that self-assessment. So if you have a self-assessment and it's very, very low, well, there's a chance that a contracting officer is going to look at it and say, I don't want to do business with them. Moreover, there's an increasing effort on the part of primes to know a lot more about the security of their subs. Already, some primes are asking for the SPRS score, but they're doing more. Some primes are using commercial services to essentially do an external scan of your information system, one that doesn't require your consent to identify vulnerabilities. I know that the major insurance carriers do that all the time before they'll write a cyber policy now. And I've even heard just in the last day that there are some primes who are saying, not only do I want to know your SPRS score, some are saying, I'd like to see your SSP. And just yesterday, I heard that there is at least one prime that is suggesting to its prospective subcontractors that they should go through a voluntary so-called joint surveillance assessment so that they do get assessed using the CMMC, using the 171 standard. The pressure is on. And to get back to the False Claims Act, if you knowingly submit information to SPRS that you can't defend and is shown to be wrong, you are taking that exposure to an investigation, even a False Claims Act. I wouldn't do it. I defend these things. It's incredibly disruptive and personally can be, a matter of great concern, if not, threatening. Just a bad bet. You have to go to your management and say, look, for our own sake, for the sake of our customers, for our business, for our employees, we need to be better protected. And in being better protected, we also need to be compliant with the contract requirements that we accepted. And we have to inform DoD when events occur because the contract says that we must. By doing all those things, you protect your business, you reduce your exposure to many forms of liability, and you improve the prospects that you will be chosen by DoD or by primes because you have more security. And you can get insurance. I mean, let's call it a quadruple win as opposed to the triple loss that I suggested earlier.
Bob, my last question on the existing contract requirements that most in the audience have, and that question deals with the DFARS 7020 clause, which gives the DoD the ability to have access to contractors' IT systems. Can you summarize the gist of the DFARS 7020 requirement?
Sure. Well, there are three elements to it. The first concerns the self-assessment that you submit based upon your use of that DoD assessment methodology. That's the thing that goes into SPRS. Well, 7020 clause says that this basic assessment is something everybody has to do, and it's based upon the review of your system security plan. Well, you'd better have one since it's supposed to be based on that plan. But it results in a low confidence level. In the reg, it says government only gives us a low confidence level. To get a medium level of confidence, then you get into what's called a medium assessment. And that's also discussed in 7020. And I've described that earlier, but I'll just say here what it says in the reg. A medium assessment includes a review of the contractor's basic assessment, that is your self-assessment, and a thorough document review, which always includes the SSP and can include more, and discussions with the contractor to obtain additional information or clarification as needed. And DCMA, through its DFCAC unit, are calling companies now just to ask just those questions. How'd you get to this score? What is it? What supports it? What evidence have you got? They don't go on site to do this. They do it over the telephone. But you're going to feel awfully uncomfortable if you put in a score that you can't support and you don't have an SSP. And I don't want any employee or any officer or director or any board member to be looking at that discomfort because they've misled the Department of Defense and therefore the United States as to their self-assessment. Don't do it. But there's also the DFCAC high assessment. And that's been going on for a couple of years now. Now that's more intensive. It typically involves an on-site assessment that usually lasts about 5 days. And in that situation, DFCAC will send a team of assessors. But first, they will ask to see your system security plan roughly 5 weeks before the event. They expect you to collect evidence of your compliance across the range of the 171 requirements. They'll expect you to identify contracts that are appropriate to test your system against. They'll want to know what the system boundaries and architecture is. They're going to want availability to talk to your subject matter experts on elements of compliance. Now, until very recently, the DFCAC high assessments were done only of the larger DoD primes. And many DoD primes wanted those because, again, it shows their customers that they are more secure. But we've had over the last 2 or 3 months this new joint surveillance assessment program, which applies the same standards and process basically, but uses the now available certified third-party assessment organizations, C3PAOs, who are trained under the Cyber AB and accredited by with DCMA authority. So they essentially accompany DCMA in doing these high assessments. But here's the key thing. Instead of having maybe a dozen or 2 dozen DCMA assessors, I think now that there are more than 29 C3PAO organizations and more coming online all the time. So, the resource base that's available to do assessments at the high level has suddenly expanded. And I believe that there are about 50 companies, largely primes, but not all, who have signed up to do a joint surveillance assessment. This essentially is a test of your SSP and your compliance with 171. And if you get a good result from that joint surveillance assessment, that's a calling card, a credential that you use with the government as a competitive discriminator with prime contractors. And I have heard instances of where even smaller companies who are largely subs are looking to get this done because they can separate themselves from others who don't have that credential.
So Bob, actually it turns out that, we had a small to medium customer of ours who was picked by DFCAC for a high assessment. We don't know exactly what the criteria that was used to pick them, but they were picked for a random assessment and fortunately had the ducks in line with the SSP, a strong CUI protection system, and ended up getting 110 out of 110. But certainly from our vantage point, even though I don't know any reason why they were picked, but the DIBCAC high audits are now being implemented at random on SMBs. With that, let me move on to CMMCs. So thus far, we have been asking you questions about compliance and with existing contract regulations. CMMC is expected to be an interim rule, perhaps in March 2023. But CMMC is the exact same 110 NIST 800 171 requirements. And so sometimes that can confuse a contractor. So can you share with us, what's the relationship of CMMC to existing DFARS 7012 requirements? And what are the differences between DFARS 7012 and CMMC when ostensibly both of them have the exact same requirements to meet 110 NIST 800 171 controls?
Well, I mean, the principal difference is that when CMMC is in effect, companies that have the CMMC clause in an RFI or RFP or contract, they will be required to pass a CMMC so-called level 2 assessment. What's a level 2 assessment? It's essentially an assessment against the same 171 standards using basically this existing 171A assessment guide. Those requirements of 171, the assessment guide for 171, they're still the core of CMMC. The principal difference is that an assessment will then be required. And if you satisfy the assessment, you get a certification. And if you have that certification, then you are eligible to perform contracts or subcontracts where that certification is required. But, you know, today, 7012 is in place, and 7019 is in place, and 7020 is in place. And 7012 requires you to have adequate security and to implement 171. 7019 requires that you do the self-assessment as to your satisfaction of 171. And 7020 says that DCMA has a right to talk to you or come inspect, you know, your facilities as to, you know, the evidence of your compliance. You know, essentially the same obligations that you have today will exist at the time this new CMMC regulation comes into place. The big change is that we will roll out these mandatory assessments. Now, does that mean that you can wait until then and do little or nothing? I think that's a very bad idea.
So let me ask, sorry to interrupt on that. I'm going to ask you a question that was asked to us on a prior webinar. It was an SMB contractor, and the gentleman said something like this: look, this full CMMC rollout timeline is that it'll be implemented over several years. Therefore, you know, let's go wait and see. Let me wait for 3-4 years before I implement 800 171, because initially only a few contracts are going to have CMMC, so I can wait. What's the issue with that argument?
Many. I'm just taking a note here. Look, I didn't mention at the outset that one of the reasons that I get some attention in this area is that I've done a variety of work, for on behalf of the government. I served on a Defense Science Board cyber supply chain study, and then I've been a consultant for the MITRE Corporation for much of the period between 2017 and today. And in the course of that work for MITRE, and especially for the DSB, I got a pretty good look into the threat picture. It was ugly a few years ago, and it has only gotten worse, especially with this, proliferation of ransomware. So what's wrong with waiting until the new regulation is effective? Well, first, the risk that you take of cyber attack and its consequence to your business, that's not waiting, that's present now. The contract obligation that you have to satisfy 171 and have a system security plan and be able to demonstrate that you follow that plan, that doesn't wait until the new regulation, that's imposed now. The legal exposure that you have if you fail to fulfill those contract obligations, or if you fail to have adequate security and you have third parties sue you, that's present now. Those things don't wait for the effective date of the CMMC regulation. They are here now. And also, to really be secure and to satisfy the 7012 clause, which remains at the heart of CMMC, to be secure can take some time. And you want to use that time. You do not want to find yourself in a situation where you do eventually get that where you get that CMMC requirement, and then you have to start then. It can't be said enough, and it's certainly been said by many experts, that first, that even minimally sufficient security can take most organizations time. But organizations with good governance, risk management, and compliance, they're going to start with minimal sufficiency perhaps, but they're all going to move towards better security to actually be secure in a dynamic environment. And this is a continuing investment. And I want to emphasize this point. CMMC compliance, don't use the term. CMMC isn't the present requirement. 7012 compliance now. 7019 and 20 compliance now. 171 now. And those are things that protect your enterprise and keep you on the right side of law and compliance obligations.
Well, Bob, just a slight nuance over here. I think the points that you make are absolutely on point, but perhaps I interpreted what this gentleman was saying something like this. Look, CMMC is going to be implemented over the next 4 years. So it's going to slowly creep into contracts, and therefore my likelihood of being in the contracts is, in their judgment, maybe in the outer years. Therefore, I can wait. What's the fallacy with that argument?
Well, I thought that I just emphasized, because the central fallacy is that you are ignoring your present contract requirements, regulatory obligations, legal duties. All of the duties of cybersecurity to protect covered defense information, they are all present right now. And the fact that the CMMC addition of a mandatory third-party assessment, the fact that that may not come to you for 1 or 2 or 3 years doesn't change at all the present compliance obligation. As I said earlier, the way government contracting works is that companies are expected to comply with the requirements in the contracts that they take. And it has never been an excuse for any non-compliance that, well, I didn't know when you would get around to an assessment, audit, investigation, inquiry, or question and answer. You are expected to comply when you take the contract and to continue to comply. This idea that it only is meaningful when there's a third-party assessment is kind of crazy. Because if that were applied across the board of government contract requirements, it essentially would invalidate so many obligations that are in fact imposed by law or regulation or public policy. This happens to be one area, one of the relatively few, where eventually there will be widespread third-party assessment. But the obligation to comply with the basic cyber dictates of 7012, it exists today. And if you will, the third-party assessment is just reinforcing it, but not changing it.
Well, Bob, if I may say so, I've done a fair number of these webinars, and I believe that the clear and concise, guidance that you've provided in understanding what these regulations are and what they mean to the defense industrial base has been unrivaled. I want to thank you very much for your sage advice, for clarifying for us what these regulations mean. And in the interest of time, wish everybody who's attending happy holidays. And thank you, Bob, again, for participating, and for our audience for tuning in to listen to your advice.
Thank you, and happy holidays from me as well.